Good morning and welcome to the Spotlight video series where we discuss cutting edge employment law issues in the news. I'm Tom Spiggle, founder of the Spiggle Law Firm, a firm that helps people who've been fired or afraid that they might be. And in the Spotlight today, I'm thrilled to be joined by Michael Ludwig, who is a very experienced attorney in our office. And today, Mike, I think we're going to be talking about federal sector, right? Federal sector cases.
Yes. Yeah. Good morning, Tom. Yeah, we'll be talking just kind of an overview of what federal sector employment cases are, what they look like, and then maybe a step-by-step process of how you can kind of go through the EEO process. So just the beginning of the topic, what is federal sector like employment law, or how do you know if you're within federal sector employment if you're making a discrimination or retaliation complaint? So that would be if you're within a federal sector or a federal government agency position. So if you work for the United States Department of Defense, if you work for the United States Department of Agriculture, or if you work for it can be other. It doesn't have to always just be one of the larger federal government positions. It can be with the if you're an employee with the National Labor Relations Board itself, or if you're an employee with TSA, that's another federal sector job. So it can also sometimes cover employees who are within government contractors if the actual employee, like the officers, the management officers who take the discriminatory actions are federal agency employees as well as the managing officials. For contractors, that can be kind of on a case-by-case basis, but I've certainly had cases where an employee was employed by the federal contractor and worked with federal sector managers, and those managers took the discriminatory actions, and so that can be sufficient for an EEO claim. So how you go about filing an EEO claim, and we keep saying the word EEO, that's equal employment opportunity. Every federal agency or every federal body that employs people has its own EEO agency. So that's different from the private sector, where if you want to file a complaint, you have to file with the Equal Employment Opportunity Commission, which is in and of itself a third-party agency. With EEO cases in the federal sector, you would want to go to your employer's federal EEO office, Equal Employment Opportunity Office. So you should be given information about that from either HR or from the EEO office itself. But that would be the first step in making an EEO claim. And that's important because EEO federal sector claims, you have 45 days to make your initial EEO contact. And initial contact can be just going to the EEO office and saying, hey, I feel like I've been discriminated against based on my race, based on my religion, or I reported a discrimination to my manager or to HR, and now I feel like I'm being retaliated against. That is sufficient to start having that conversation and saying, okay, I want to begin filing out a complaint. That starts your EEO process. So you'll want to do that within 45 days, which we know is a bit sooner than the 300-day deadline for private sector employees. So that's something to keep in mind. And then the other aspect of this case is just the timeline of how matters within the EEO go, how federal sector matters go. Because once an EEO complaint has been made, a federal sector EEO complaint within an EEO office, then that starts a 180-day clock that the EEO, that your federal agency's EEO investigator has to investigate the claim. And so that is so at the end of that 180 days, you should receive what's called a report of investigation, or an ROI, which is all the documents that are related to your EEO complaint. And along the way, as Tom, I'm sure the EEO investigator will have a affidavit. They might have a list of questions for you to fill out if you're an employee making that complaint. They might want to have a remote interview in which they ask you questions, and then they give you a written transcript of that interview for you to confirm. They'll also do the same for management officials who you have accused, or we have accused of being discriminatory or retaliatory. We'll get those management affidavits, and then employees who make those complaints will have an opportunity to review those management affidavits and then file a rebuttal. Essentially, look at my supervisor who's taking these discriminatory actions, they then provide a kind of a response or a justification for their actions, And if the statements in there are not factually accurate or leave out important background information, then you can include that in there and essentially rebut those statements. And then at the end of the 180-day schedule, so long as there isn't an extension, sometimes an EEO investigator can ask for possibly a 90-day extension if they need more. But at the end of that 180-day deadline or an extension, you'll receive that report of investigation. And then employees, federal sector employees, have the option to either request a final agency decision, essentially put the decision back to the agency with all the information from the report of investigation, or they can ask for a hearing before an administrative judge with the Equal Employment Opportunity Commission. And that's the third-party organization I mentioned before that private sector employees use. Now, in my experience, I've almost never recommended the final agency decision to clients, just because I don't really trust the agency to, even if the evidence is overwhelming or very clearly pointing to a discriminatory or retaliatory action, I usually don't trust the agency to make that decision to kind of police itself in that way. So my recommendation 99 out of 100 times is to go with an EEOC hearing, with a hearing before an administrative judge, because then your information can be before a neutral third-party administrative judge whose job it is to adjudicate these cases, and they have no interest. Again, this is a third-party body, so it's not like you're going back to the agency to tell them to police themselves. So, but those are just kind of the deadlines to look out for. It's 45 days after any kind of incident that you believe is retaliatory or discriminatory has happened. You'll need to contact your EEO office, and then once that investigation has begun, the 180-day period should end with a report of investigation, with which you can most likely then ask for an EEOC hearing before an administrative judge. So,
yeah, very helpful. And I think as we were talking before we jumped on the camera, there's a lot of confusion about what the ROI is, which is understandable. I think, as you were saying, a lot of people expect it to be a decision, right? Like either you're right or you're wrong, and that's not what it is. It is just basically what we call the record. All the statements, all the documents, they then can be used either in a final agency decision, which we don't recommend because it's like asking the fox to guard the chicken house, right? Or going to the EEO judge.
Right. And the report of investigation is usually several hundred pages. It's usually a very large document, which is good. We want a voluminous record. And when you go to the EEOC hearing process, you can have additional discovery on top of that. But as Tom said, the idea behind the report of investigation is to have a really comprehensive record of the entire case, so that when you're before an EEOC hearing, you can, most 9 out of 10 items you're pointing to will likely be within the report of investigation. And because that's a document that the EEO investigator has compiled rather than us having to have discovery with the other side, it also can save clients money, because discovery can be expensive even before an EEOC hearing, and there can be discovery after a report of investigation. But in my experience, most documents that I end up citing before an EEOC hearing is from the ROI. So it's just nice to have that kind of voluminous document that allows all those information to be gathered in one place, and then prevents there for a need to have a large discovery process with an opposing counsel, which might be more costly it's just more cost effective to have that report of investigation be gathered before the hearing.
Yeah, I think that's an excellent point. And I would just sum up by saying that, obviously federal sector litigation that you're talking about is a subset of employment law. So for those folks who are out there and who need a lawyer, you want to make sure that you have somebody like Mike who has experience in federal sector. There are a lot of people who have like you do, Mike, have experience in private sector and federal sector, but there are a lot of people who just have private sector experience, because most people, that are in the private sector. So if you're out there looking for an attorney, you want to find somebody. If you're working for the federal government, you want to find somebody who has federal sector litigation experience, because it is a specialized area of the law. So anything else before we call it quits, Mike?
I was just going to kind of add to that point and say that, it's the same. It's the EEO covers federal government employees. And as Tom said, it's good to have someone who has that experience, because it's the same. We're operating with the same laws. It's the same legal aspect, but procedurally it is very different. And so if you're not as familiar with the deadlines or with the process, it can kind of especially because these deadlines are shorter than you typically have for private sector employee cases. You want to make sure you hire somebody or are able to be on top of those deadlines, because that can be the biggest issue, more so of a procedural issue than actual like different legal claims.
Yeah, absolutely. All right, Mike, this has been very interesting. I appreciate you taking the time this morning. I'll let you get to the next thing on your desk.
Okay, thank you.
All right, take care. Bye-bye.